Hi, I'm talking today to U.S. Attorney Sherrie Abney. Hi, Sherrie. Thank you so much for allowing me to interview you for Askimo's International Library of Interviews with Experts.
Hello, Joanne. You're very welcome. I'm glad to be here.
Wonderful. Great. Sherrie, today we're talking about the differences between collaborative law and mediation. So let's begin with, what is the definition of collaborative law?
Collaborative law is a confidential, voluntary, non-adversarial form of dispute resolution which relies on interest-based negotiations rather than having the parties' lawyers engage in positional bargaining. In other words, the process focuses on satisfying the needs, interests, and concerns of the parties instead of relying on offers and counteroffers of money. In adversarial forms of dispute resolution, the parties' primary interests are many times ignored, and the parties advocate much of the decision-making responsibility to their lawyers, the courts, and the law. The collaborative process must be entered into voluntarily since it requires the parties to sign a contract, which is called a participation agreement, and it also requires the parties to actually participate in what's going on in the case to a much greater extent than they do in litigation. The agreement states, among other things, that the parties have chosen to voluntarily exchange information regarding the dispute and to settle out of court. If the parties fail to settle, the collaborative lawyers must withdraw, and the parties must hire new lawyers to go forward if they choose to proceed with litigation. Now, the withdrawal provision is what distinguishes the collaborative process from other forms of dispute resolution, and there are several good reasons for requiring it. First, since the lawyers know they won't be able to continue representing their clients at the courthouse, and the clients understand that they must retain new counsel to continue beyond the collaborative process, this discourages people with the wrong motives or people who do not intend to settle from ever entering the process in the first place. Next, the withdrawal provision allows the lawyers to concentrate and focus 100% on creating options with the parties for resolution rather than going through the schizophrenic exercise of trying to settle one day and preparing to go to trial the next. And finally, and most importantly, the withdrawal provision provides a safe environment for the parties to exchange information because those parties are much freer to be honest with each other since they know that no lawyer in the room will ever be able to cross-examine them regarding anything that they have said.
What are the differences between collaborative law and mediation?
Well, mediation varies around the world. In the United States, most mediators employ positional bargaining and caucus sessions. This means that the parties' lawyers, with the approval of their clients, are expected to come prepared with offers and counteroffers that they have gotten together in advance of the mediation. The offers are often based on the amount of blame they expect to be able to attribute to the other parties, or statutes that might allow their client to escape any responsibility. Plaintiffs always ask for more than they expect to get, and the defendants always say they will pay nothing or less than what they expect to pay. The lawyers and the parties separate into different rooms, and the mediator then proceeds to go back and forth, carrying offers and counteroffers while he or she attempts to reason with preconceived notions of the parties and the adversarial posturing of the lawyers. The amounts in demand and offers to pay often have nothing to do with the true interests and concerns of the parties. In addition, the process is frequently done in one very long, drawn-out meeting, which sometimes results in parties agreeing due to exhaustion and having buyer's remorse the next day. In the collaborative process, parties meet for several 2 to 4 hour sessions. Clients are encouraged not to have selected a particular amount of money or an option as their goal before they attend the first face-to-face meeting. Each party is asked to be prepared to explain what that party's primary interests and concerns are and what he or she would like to see come out of these meetings. Each party and lawyer must also be prepared to listen to the other parties as they explain their interests and concerns. In a well-run collaborative case, the parties will often do more talking than the lawyers. Mediation, as it is used in litigation, looks backward to place blame. The collaborative process looks forward to what is necessary to remedy the problem. And I think that's primarily the greatest difference.
What are some of the reasons that you feel people should settle out of court?
Well, there's many reasons that people should settle out of court, and the importance of the various reasons will vary according to the particular dispute. In probate and family matters, the collaborative process provides a great advantage if the family would like to remain on speaking terms. If a business owner has a dispute with a major supplier, and that person is very important to him, he doesn't want to destroy that relationship with an adversarial court case. If an employer has a supervisor accused of sexual harassment or discrimination, he would certainly prefer a private settlement of the dispute rather than an open court battle. Let's say a contractor is working on a building and something goes wrong. He is concerned about getting it over with, getting his money out of that project so he can go on to the next one. But I think the single most important reason that people should settle out of court is that the courts are not capable of providing the relief that many parties want and need. The courts can order defendants to pay money, but they cannot order a hospital to change the emergency room patient safety procedures that resulted in the death of a child, nor can the courts order a design of a product to be changed to prevent another person from being maimed or killed. In a discrimination case, the court cannot order a company to pay an outside provider to train employees regarding discrimination or sexual harassment. But plaintiffs in a collaborative case may agree to settle if the defendant will commit to do something that may be more important to that plaintiff than money. Since over 95% of all cases never get to trial, it appears that many disputes could settle early. But early settlement also prevents extended discovery battles, which is very profitable for law firms.
Within any dispute, whether it's divorce or otherwise, what if the other party and I can't reach an agreement on almost everything, but there's one point that we're stuck on? Would we have to lose our collaborative lawyers and go to court?
Sometimes it's difficult to know exactly when collaborative lawyers will withdraw, and probably collaborative lawyers will not all agree on exactly when this should occur. I believe that if there's a dispute, let's say in a family case over the value of the community home or some other piece of property, whether or not the lawyers would withdraw would depend on how the parties and the participants in the process approach the problem. If the lawyers hired an appraiser and the parties agreed to go by the appraiser's opinion, that would result in an arbitrary decision. If there was only one decision in question and there would be no argument by the lawyers, I don't believe they would have to withdraw to have an expert/arbitrator decide the question. However, if there was disagreement about the facts and there was a chance for a situation to become adversarial, requiring testimony and arguments by the lawyers to support clients' positions, the lawyer should, in that case, withdraw. However, an expert can be brought in to determine many kinds of questions. If the parties will agree to accept an objective, neutral opinion, this seems to me to be a better solution than chucking the whole case and sending them off to litigation.
Why is collaborative law such an effective settlement process?
The process focuses on the parties and what they want to see happen. Litigation focuses on lawyer strategies, statutes, case laws, the courts, and the legal system, which often doesn't have a lot to do with what the parties want to see happen. Often the real problems leading up to the dispute are never addressed in litigation. I have heard other lawyers say, I just wish I could talk to that lawyer's client and find out what he really wants. In the collaborative process, he can do that because he's sitting face to face in an informal situation discussing what the parties want rather than what their rights happen to be under the law. If you have a coupon for a free strawberry ice cream, but you hate strawberry, your right will not be very satisfying. But under the law, strawberry is the only right you have. In the collaborative process, you would have the opportunity to tell the other party what you really want. And sometimes you'll get chocolate quicker, easier, and with much less expense.
Thank you, Sherrie. Thank you so much for talking to me today.
You're very welcome.